Welcome, everyone. Welcome to the Environmental Lawcast, a bi-monthly podcast where we host an expert every 2 months. Today, our expert with us is Mr. Owen McIntyre. We are very pleased to have him here with us. Owen, will you please tell us a few words about yourself?
Thank you very much, Raphael. My name is Owen McIntyre. I am a professor of environmental law at University College Cork, which is one of the 4 constituent universities under the umbrella of the National University of Ireland. I've been a specialist in environmental law for, I suppose, for around 35 years now, slightly more than that. I became interested in environmental law actually in my first job after college, where I worked as an in-house lawyer with an American technology company. And though it wasn't my first choice, as the last person in the door to join the legal team in the very late 1980s, I was charged with environmental compliance, environmental risk, etc., on behalf of this company's operations in Ireland, which was its European headquarters. So everything becomes interesting eventually. And the more it was a very interesting time in environmental law. Environmental law was evolving very quickly. The late 1980s, early 1990s was when much of the new legislation that we have in most countries in Europe, for example, was developed in the late 1980s, early 1990s. So it was rapidly changing. This created all sorts of challenges for business and industry and for the regulated community generally, as well as for government and regulators. So I had a crash introduction, if you like, into environmental law. I had to get up to speed very quickly. I found it fascinating. I found it very interesting. I was watching it evolving in front of my eyes. And that, of course, is always very exciting. But within that, I always had an interest myself in terms of international environmental law, and particularly how do states regulate, how do they cooperate on difficult regulatory challenges, difficult environmental challenges? How, for example, do states manage a shared resource without the temptation to plunder that resource, to use it as quickly as possible in such a way that may not be sustainable, but would mean that that state would get the best advantage? So if we think about marine territory or fisheries or living resources, or my own particular specialism is water resources and rivers, major international rivers and lakes. So that was always a very interesting challenge. I had the opportunity to teach environmental law from 1990 or 91 on in the UK. So I took that opportunity and I started to engage in research in that area. I completed my doctorate. I wrote several books in that area, started to publish articles, started to manage research teams, and still continue to be active in all aspects of environmental law. So domestic, comparative, EU, across various sectors, and international, but do more and more in the area of international environmental law and more in the area of international water law.
Okay, so when you talk about managing shared resources, what you focus on the most is water, right?
I do in my own research, but I mean, I'm interested in climate, I'm interested in living resources. So everything from fisheries to, ecosystems and the protection of forests. And I mean, one of the things that we learn as we go on is that all of these issues are connected. They're all entirely connected. So one can't simply be, although it would be lovely, I'd love to stay in my comfort zone. It'd be lovely to be an international water lawyer and only to focus on the management of water resources. I'm currently leading a project on behalf of the World Bank on governance of the hydrological cycle. Now, the issue with this is that we had traditionally, when we looked at river water resources, we assumed that the correct scale at which to regulate was the drainage basin. So a major river system, there may be 4 or 6 or 8 or 2 countries that share that river system, that it could be regulated at the level of the river system. So those 2, 4, 6 or 8 countries could cooperate to manage the basin. However, increasingly with climate change, we see that patterns of evaporation, transpiration, and precipitation are changing. So forest loss in one part of the world may have catastrophic effects on rainfall in another part of the world. So the basin scale is no longer adequate. So increasingly, things I'm looking at in terms of water resources and the protection of water resources include the protection of forests, the management of wetlands, perhaps even in another continent. So all of these things are absolutely connected. How do states in one basin, how might they exert pressure on states on another continent to maintain their forest cover, to maintain what we call evaporation sheds? Well, usually using wildlife law, international biodiversity law. So to try and put pressure on those countries that are rich in forest cover, that manage evaporation sheds, that they need to protect those evaporation sheds as habitats for endangered species, protected species, etc., etc., etc. So all of these areas are intrinsically linked and connected.
Okay. And what usually causes the biggest disagreements between the states and their usage of water? For example, if 2 countries share the same body of water, how would they settle and not fight over it?
Yeah. The biggest disputes usually arise around projects, around infrastructure projects. So a state upstream may inform their neighbors that they want to build a major hydropower dam. Again, that's linked to climate change. They will say this is for climate mitigation, so that they can generate power from renewable sources like hydropower, rather than using fossil fuels. But downstream neighbors will say, well, that's going to have impacts on us. You're going to have to fill a dam. That may take 3 years. That's going to deprive us of precious water resources during those 3 years. It's also going to give that upstream state a measure of control over the lower stream state. They can restrict water flows downstream. They can change the timing of water flows. One of the problems is that when the upstream state requires power and therefore is happy to release water, may not be when the downstream state needs the water. The downstream state will need the water in the dry season. The upstream state may want to generate power in the colder, wet season. So, it changes flows, it changes the power dynamics, it has major economic impacts, and of course, increasingly, what we look at is it has major ecological impacts. That rivers are, as well as economic sources of water, they are large, complex, important ecosystems, and those ecosystems provide a great many ecosystem services: food production, clean, fresh water, amenities, the recreational value of beautiful lakes, the aesthetic value of lakes and rivers, cultural values, etc., etc., etc. So these can be complex disputes can arise, and for states to try and agree on ways to each benefit from these uses of water, the development of river basins. And so, as I said, it's very often about infrastructure, about the development of infrastructure. So how can states work to develop these together? If states cooperate, if states communicate effectively, very often there are win-win scenarios. The upstream state may develop hydropower, but in so doing, perhaps they would also develop increased water storage. That could be interseasonal water storage. That might mean more water would be available for the downstream state during the wet season. The infrastructure could be designed and operated in such a way to ensure optimum flows that maintain ecosystem and maintain the ecosystem services. Fisheries may be very important downstream. That means you must have water at particular times of the year. Perhaps a large hydropower dam upstream can be designed and operated in such a way that can help to maximize and optimize fisheries or recreational use of waters or whatever. So with communication, with cooperation, states can cooperate to sort of optimize. And this is one of the overriding objectives of international water law, is to ensure optimization of what is an increasingly scarce resource. Humanity uses more and more and more water exponentially. Our demand for water increases exponentially. It's linked to our demands for food. It's linked to our demands for energy. It's linked to affluence. When people have 3 bedrooms or 3 bathrooms in every home, they tend to use more water than when they don't. So we have an increasing problem of water demand. Water demand continues just to go up on an exponential trajectory, but water is a finite system. And climate change is impacting even on the regular availability of a finite amount of water that we could in the past rely upon. That's not so true anymore, with changing patterns of precipitation and evaporation.
Okay, so you would definitely agree that climate change drives your work and your research.
It's one of the drivers. It certainly has to be taken account of. So ultimately what we're seeking to achieve, of course, is water security. Climate change undermines water security. Where we understood what water security was 30 years ago, that is no longer the same thing. One of the things we have with changes to the hydrological cycle is an acceleration of the hydrological cycle. So in many parts of the world, we have more rain, more precipitation, or more snow. But that precipitation is occurring earlier, is occurring more in the season, is occurring more in a more intense manner. So it causes flooding and longer droughts. So the dry season may be rather longer. The wet season may be more intense, maybe a major risk in itself because of problems of flooding. We see this now all over the world. Most major rivers in the world were fed through snowmelt. So large amounts of, if you like, snow-capped mountains were reservoirs of water. And as the snow melted coming into the spring and summer, when water was needed, that released water into these major systems. We could rely on this going back all through history. No longer. We see that snow caps are retreating. We have melt much earlier in the season, so there's less storage, and that storage is much shorter than it used to be. So these patterns are changing. Now, that is to explain the significance of that risk. In major basins like the Ganges or the Mekong or the Brahmaputra, where hundreds and hundreds of millions of people rely on that water to live, food systems, agricultural systems have developed on the basis of an expectation that we will have enough water coming from snow melt from the Himalayas and the Tibetan Plateau that we will be able to irrigate, to grow rice, to grow wheat, etc. We can no longer rely on that.
As we know, climate change is the main reason for sea levels rising, but for countries like Tuvalu or small Dutch islands, how are they planning on fully being immune to the sea level rising? And what is a country without any land? For example, Tuvalu could lose all of its territory if the sea levels don't stop. So what is your view on this?
Well, I think it's a tragedy. I think much sea level rise now is unavoidable. That it's already baked into our climate system. If we absolutely stopped using fossil fuels today, I think we would not stop some measure of sea level rise, because I think climate change is baked into our climate system. This is one of the problems with our elevated levels of CO2 and other greenhouse gases in the atmosphere. Now, of course, it wouldn't hurt to reduce or cut our emissions immediately, but I think a certain measure of this is now almost inevitable. The most vulnerable communities are these low-lying states, but particularly low-lying small island developing states. It's unlikely that states like Tuvalu would be ever in a position to build the kind of infrastructure, for the billions and billions that would be required to build flood defense infrastructure for those islands. So I think we're already starting to see the first official climate refugees. The population of certain Pacific islands, some elements of those populations are now being granted residence rights in Australia and compensation going to those countries. We've already had, in a very, very important advisory opinion handed down in July of 2025 of this year by the International Court of Justice, they talked about the continuing existence of marine territory, even for states that have disappeared. So places like Tuvalu, even if they were completely inundated and disappeared as land masses, that those states would continue to exist in terms of maritime territory. Now, that's a statement, that's an advisory statement from the highest court in the international system. But what that will eventually mean in practice, I think, is open to debate. To the extent to which those communities can maintain a national identity, can maintain a coherent national purpose in the absence of territory, I wonder. I'm not sure. So we're likely to see some tremendous disruption, huge disruption to our system of international states, to our community of international states, and our system of international law.
One recurring issue in environmental law is enforcement. In context of water production, when do enforcement mechanics most often fail? At the international level, or the national level, or in general, both international and national levels?
At both. I mean, when we look at international, there's two things I'd say to that question. It's a very good question. When we look at the international law generally, and probably more particularly when we look at international environmental law, that there is or there appears to be a problem of enforcement. Remember, we're not dealing with normal actors. We're dealing with states. States are not normal actors. So we shouldn't expect that international law functions like domestic law. In domestic law, you have courts, you have policemen, you have prisons, you have, a monopoly of force, a monopoly of coercion. So ultimately, if you live within a country, if you're a citizen of a country and you reside within a country, you will obey that country's laws. Eventually, there is no avoiding it, because that country has the power, has the authority to coerce you to do so. Now, in the international system, we have a community of roughly 200 states. And several of those states, there is nobody ever going to coerce them to do anything. Nobody is going to coerce China. Nobody is going to coerce the United States. Nobody is going to coerce France or Britain or Germany. These are major states. These are, often nuclear-powered states with large armies, with their own currency, with, major trading presence, with, nobody is going to sort of take that state by the ear and drag them to court. States, of course, must consent to go into any dispute resolution process. So the court, one state very rarely can take another state to court. They have to agree to go to court, unless they have a treaty where they have already agreed that any dispute will go to court at the request of one party. Usually they have to agree. And not alone do they have to agree a treaty on what questions precisely the court may hear. So they will agree a compromise, which will agree exactly that only 3 questions will be dealt with by the court: question 1, question 2, and question 3. So yes, there is a problem of enforcement in the international system. Now, when states agree to be bound by certain rules, when they sign a treaty and ratify a treaty, or when they sign up to a declaration or a statement of principles, they will often ratify those arrangements in their domestic law. And if they do so, enforcement really lies within the domestic system. So, for example, a lot of climate litigation today is taken by civil society actors, by non-governmental organizations, who take an action against their own government to say that their own government, in adopting a climate mitigation plan, for example, under legislation, that government is failing to meet its own legislation, its own commitments, either commitments which are expressly set down in a climate act and reflect that state's commitments in the international arena, or that the state is failing to interpret its obligations under its own climate act in line with its commitments in the international sphere, its commitments to the international community. That kind of litigation is particularly common at the moment in climate litigation. So the domestic courts are terribly important. We must not forget about domestic enforcement. But I'm going to come back to this question of enforcement at the international level. States can very rarely force another state to go to a court, to go to dispute resolution. And sometimes people assume that is an enormous problem. Oh, international law has limited enforcement power in the international system. Therefore, it's useless. But that isn't quite true. It misunderstands what international law is intended and designed to do. That rather than provide a binding system of enforceable laws and rules, the international system actually does something else, or mainly, principally, does something else. An English international lawyer, Malcolm Shaw, he explained, talking about international law generally, he said, what is the main function of international law? He asked this question, what is the main function of international law? Now, this is very true of international environmental law and, for example, of international water law. This works really, really well. It's absolutely true. He asked himself, what is the main function of international law? And his answer was to create a culture of communication. In other words, to provide a mechanism or a means or a medium through which states can communicate effectively. States are very difficult actors. States have sometimes huge power, financial, military, diplomatic. States have egos and pride, and states can be very, very, very tricky actors. It can be very difficult to get states to cooperate and to do things and to work together. So he said that international law provides a culture of communication. Now, he explained that by saying elements of this include that international law provides shared understandings, that there are basic understandings. We may not fully understand the precise implications of these understandings, these principles, these broad ideas, but all states agree on them. Think, for example, of sustainable development. Have we heard of a state saying there's no such thing as sustainable development? No, they all agree that sustainable development is the overarching objective of much of their international engagement. They may not agree on what it means. They may not agree on what it means precisely in the context of a particular project or a particular dispute, but they all agree that the key objective is sustainable development. So this idea of shared understandings. It also provides a common language. And that common language is an enormously important feature. In my own area of international water law, we know what we mean when we say a river or a drainage basin. We know exactly what that means because the international system has spent decades defining it. And we have a clear definition of what exactly that means, that it includes the territory within the basin. It includes land use activities which impact on water. We know what we mean. So states don't have to spend, if two states want to sit down to talk about the management of a shared river, they don't have to spend 4 years arguing over what that agreement will cover. That's already been done. So we have shared understandings around big ideas like environmental protection, sustainable development, equity. We have a shared language, a common language, and together those provide starting points for states to cooperate further. They help states to develop agreements, to develop further procedures and mechanisms for cooperation. And so international law is not necessarily a set of binding obligations. You must do this, you shall not do that. Very, very difficult to present rules of that sort to, as I said, China or the United States or France. But when states want to cooperate, when they think it's to their advantage, they can optimize their resources, they can, protect the environment to everyone's benefit. We have starting points for states. This is how we communicate. This is the language that we use. These are the mechanisms that we use, and these are the goals that we will pursue. That's a great deal. That's a big help, a very good start, if you like. So enforcement, of course, is an important issue, but I think sometimes it misunderstands the purpose of international law. Sorry, that's a very long answer.
No problem.
Angela.
What do you think is the most effective way to hold the states accountable for their environmental law, like courts, international tribunals, negotiation? What way?
Traditionally, we see 3 ways that states can be held accountable. There seems to be sort of, generally 3 categories or 3, what we call them, modes of compliance. And we tend to refer to these as first party, second party, and third party. First party is where a state holds itself accountable. Now, that's not because the state is necessarily such a good actor. It's not necessarily because the state is somehow altruistic and, inherently compliant. It usually means that conditions internally within that state's political system, legal system, require the state to comply. For example, certain states in their own internal constitution states that what they do will be consistent with international law. Quite a few states do this. So when they adopt, let's say, a climate law, that climate law would have to take direct account and be consistent with their commitments under the Paris Agreement, for example. They're, what are called NDCs, nationally determined contributions. In other words, each state makes a commitment that they will reduce their greenhouse gases by this much in the next 5 years. So if they introduce a new climate law, they really do need to do that because their own constitution says they must do it. And if they don't do it, they will be challenged. So there will be NGOs in their country that will challenge them. Other factors can be very important. For example, in countries that are democracies where there are coalition governments, and there may be 3 or 4 parties in a governing coalition, there may be a Green Party in that governing coalition. And that Green Party may insist that their international commitments are met in their legislation, or else the Green Party will pull out of government and the government will fall. So first party compliance means that states comply because of internal pressures. Second party, I'll come back to second. Second is the most important. Third party compliance is where states are forced to comply by a third party, by an international court or an arbitration tribunal, or a compliance mechanism under a treaty, or what's often called an implementation committee or mechanism under a treaty. Now, what that basically means is that the state has agreed to be bound, has agreed, maybe in the context of a treaty. And one example is that India and Pakistan, though they are often at war, in 1960, they agreed in the management of this hugely important river system, the Indus River system, that where disputes arose, they would go to the Permanent Court of Arbitration in The Hague. And to this day, when a dispute arises, one party is building a dam or increasing its water use, they go to The Hague to solve that dispute because they have committed almost 60 years ago, or over 60 years ago, 65 years ago, they committed that any dispute would go to the International Court. In the absence of that, and states rarely agree to such things, in the absence of that, many treaties will have a compliance committee. And that compliance committee will ask states to report on what they're doing, allow other states to complain if they say that a state is not meeting its obligations, and then they enter into a softer dialogue process to try and ensure compliance. So third-party compliance is not just courts. It can be mechanisms. Often compliance mechanisms are referred to as implementation mechanisms, because what they do is they seek to help a country which is struggling to meet its objectives, struggling to meet its commitments. They assist it with technical capacity, with advice, with twinning with other more developed countries, with access to technology, things of this sort. So third-party compliance can work depending on the medium, depending on the framework. But by far the most important is what we call second-party compliance. So what we see internationally is states will go along to an international conference, an international meeting, and they will say, oh, we sign up to this, we sign up to that, and they sign the resolution, sign the declaration, and then they go home and they do nothing about it at all. It's a photo opportunity for political leaders, but they don't really seriously intend to do very much about it. They're not going to spend billions. They're not going to build infrastructure. They're not going to draft new law. They're not going to bother. Think of the huge important conferences in 1992 in Rio, the Rio Conference, or the Stockholm Conference in 1972. And every 20 years, there's an anniversary conference where huge commitments are entered into. So, and this is, I think, Panjatas, what you were talking about, that states, how do we ensure that states comply with these commitments? Well, states may go to Rio and they may sign up to the Rio Declaration, recognizing the precautionary principle, recognizing the polluter pays principle, recognizing the obligation not to cause significant harm to other states, recognizing the need for transboundary environmental impact assessment of dangerous projects, recognizing all of these things. But they don't change their law, they don't take any active measures. And then 5 years later, they're in negotiations with a neighboring state. It's one thing to adopt a declaration in front of 200 states at a big party, but 5 years later, it's business as usual. And they're talking to their neighboring state with whom they share a river, or with whom they cooperate on a regional sea, or share a transboundary important wetland ecosystem. And when the others, and they're negotiating perhaps an agreement to protect that ecosystem or that feature. And then the other state says, we should include a reference to the precautionary principle. And our state says, what? Why? Who cares about the precautionary principle? And then they are reminded that 5 years earlier at Rio, they signed up to a declaration that committed them to advancement and pursuit of the precautionary principle, and all of a sudden they're cornered. They can't, because states have egos. States really care about how they are regarded. And so states want to be taken seriously. They want their word to be believed. They want their word to mean something. So when they are reminded that they have signed up to something, and now here is a concrete opportunity to put that commitment into practice, it becomes very, very difficult for states to walk away from that. I do a lot of advisory work for states, and I see this happen again and again and again and again and again. Second party compliance. Once states are reminded of commitments they've already made, it's impossible for those states to retreat from that commitment, because they want to be taken seriously. They want to be believed. They want their word to mean something. So first, second, and third party compliance. There are a number of mechanisms by which states can be pressured to comply.
Okay, so final question. If you could change one structural aspect of international water law to better protect the ecosystems and communities, what would it be?
If I could change one social aspect.
No, structural.
Structural, thank you. Well, what I would say is, I think the structural aspects that I would like to see change are changing very rapidly. So in the 1990s, in a number of hugely important agreements, the 1992 UNECE Water, and we now call the UN Water Convention, the 1997 UN Water Courses Convention. In these global instruments, the states agreed, in the drafting process, to include commitments to the ecosystems, to riverine ecosystems and freshwater ecosystems. But in truth, when those commitments were made, we didn't know what that meant. We really didn't quite understand what that meant. What were the implications of this in terms of geography? Now, how far does the law apply? Does it apply way beyond the river? Does it apply for the entire basin? The entire basin may be an entire country in some cases. So to what does it apply? How does it apply? We understood it probably meant things like protecting against invasive species, but it had to mean much, much more. And over the last 20 or 30 years, courts, treaty organizations, other bodies like IUCN, and have been developing methodologies. So things like the notion of the ecosystem approach, so that the guiding value behind all decisions are the maintenance of the ecosystem, the maintenance of a functioning ecosystem within a riverine entity. Now, that comes down to a number of things, such as ecosystem services. We identify from 2005 a very important exercise called the Millennium Ecosystem Assessment. It was completed in 2005. It gave us a typology of 4 different types or classes of ecosystem services. Now, that provided us with a language. Remember, I said that the culture of communication involves a shared language, common language. And so we now have a common language of ecosystem services, and that tells us what are the benefits which humanity can derive from a functioning ecosystem. From provisioning services such as fresh water and fisheries, to regulating services like assisting with climate change, etc., and species maintenance, all the way to cultural services. So the aesthetic values, the religious values of a functioning river. So now when states sit down to talk about values, those values now are centered on ecosystem services, and those are based on maintaining the ecosystem. And then we have other technical aspects that have developed and have been recognized by courts. So things like environmental flows. that we have to maintain a certain minimum flow at different times of the year. That is the minimum that is required to protect and maintain an ecosystem. So we now increasingly have what you would call the structural tools to achieve what had been, up to this point, aspirational ecosystems obligations or aspirational ecosystems objectives. We now have a full practical suite of methodological tools, a toolbox of methodological tools that help us to achieve precisely those elements. So I think the law, combined with the science and the sort of technological tools and approaches, has developed in leaps and bounds. So I think they're mostly in place, Angela.
Okay, thank you very much for sharing your insights with us. It was a pleasure having you here.
My great pleasure. Thank you.
Indeed. Thank you very much for taking the time and answering
Thank
our
you.
questions thoroughly.
Well, thank you for those excellent questions and for the opportunity to talk to your audience. I
Of
greatly
course.
appreciate it.